U.S. courts imposed more than $145,000 in AI hallucination sanctions in the first quarter of 2026. That's 3 months. Just the United States. Just the cases that made it to public record. Worldwide, Damien Charlatan's database, run out of the Smart Law Hub at HEC Paris, is tracking more than 1,352 cases of fabricated AI citations submitted to courts. 5 to 6 new ones documented every single day. If you use AI in legal work, this is the topic you need to understand before your name ends up on that list. This is the Hallucination Files, Episode 1. The case that started it all. Mata v. Avianca, Southern District of New York, June 2023. 2 New York lawyers, Stephen Schwartz and Peter LaDuca, submitted a brief drafted with ChatGPT in a personal injury matter against the airline Avianca. The brief contained 6 fabricated case citations. The most famous of them was Varghese v. China Southern Airlines, a case that does not exist. Avianca's lawyers couldn't find the cases. The court couldn't find them. When asked to produce copies, Schwartz did the worst possible thing. He went back to ChatGPT and asked whether the cases were real. ChatGPT told him yes. ChatGPT even offered fake Westlaw and LexisNexis references to back the lie. $5,000 in sanctions, jointly, both lawyers, the firm, and a place in legal history neither man wanted. 30 months on from Mata, the rate is accelerating, not slowing. 1,352 documented cases globally, up from 719 in January 2026. That's an increase of more than 500 cases in 3 months, the trajectory of a problem that's getting worse, not a problem the profession is solving. More than 300 U.S. federal judges have now adopted standing orders or local rules requiring AI disclosure in court filings. A growing number require not just disclosure, but certification, a signed statement that every authority has been independently verified against primary sources. The signal from the bench is clear. Hallucinated citations are no longer a novelty. They are sanctionable misconduct. 3 cases worth knowing. Whiting versus the City of Athens, Tennessee, 6th Circuit Court of Appeals, March 2026. A 3-judge panel sanctioned 2 lawyers, $15,000 each, plus the appellee's fees on appeal, plus double costs. They had filed briefs containing more than 24 citations that were wrong, misleading, or non-existent. The court did not expressly blame generative AI, but it made clear that lawyers must personally read and verify every authority before filing. This is the largest federal appellate sanction yet linked to fabricated citations. Oregon, late 2025. The State Court of Appeals set a per-item sanction formula, and the federal courts followed. In one winery dispute, the court found 15 fake citations and 8 invented quotations across several briefs, and imposed more than $15,000 on lead counsel. Oregon now prices fabrication by the unit. Johnson v. Dunn, Northern District of Alabama, July 2025. A large, well-regarded law firm. The hallucinated citations came from a practice group co-leader. The firm avoided sanction only because of how it remediated after detection. A searching internal audit, an independent third-party audit, and a full report to the court. The judge made it clear, no firm gets a pass on the substance. Some get a pass on conduct after the fact. This is not a US-only problem. Mr. Dayal, the first Australian lawyer sanctioned for AI hallucination, in 2025 by the Victorian Legal Services Board. He had submitted documents to the Federal Circuit and Family Court of Australia containing AI-generated false citations. He admitted he did not verify them. The board stripped him of his ability to practice as a principal lawyer. He cannot operate his own practice. He can only practice as an employee solicitor. 2 years of supervised practice. Quarterly reports to the regulator. Rishi Nathwani, King's Counsel, Supreme Court of Victoria, August 2025. A murder case. Nathwani filed defense submissions containing AI-fabricated quotes from a parliamentary speech and non-existent case citations purportedly from the Supreme Court. The errors were caught by the judge's associates. Nathwani apologized on the record to Justice James Elliott, Australian KC, in open court in a murder matter. The case was delayed 24 hours while the court worked out which of the cited authorities actually existed. JML Rose Pty Limited versus Jorgensen, Federal Court of Australia, August 2025. The judgment did something the legal profession needed someone to do. The court rejected the term hallucinations as legitimizing the conduct. The court called fabricated citations what they actually are: fabricated, fictional, false, fake. That language matters. Once you stop calling it a hallucination, you stop treating it like a quirk and start treating it like what it is. Why does it happen at all? Language models predict the next plausible token. Asked for a citation, the model produces something that looks like a citation. Court abbreviation, volume number, page, year, without any verification step. They are not connected to legal databases unless explicitly tooled. ChatGPT in its base form has no idea whether Varghese versus China Southern Airlines is real. It just knows what real citations look like. This is not a bug that gets patched. It is the architecture. And here is the detail that destroys lawyers in court. ChatGPT does not signal uncertainty about fabricated citations. It presents them with the same confident professional prose it uses for real ones. The fluency is the trap. If the answer reads like it was written by a competent associate, lawyers under deadline assume it was researched like one. Same prompt, 2 responses. This is the channel's argument. Ask Claude for a case citation in an area where it isn't sure, and you are more likely to get something like, "I'm not confident about specific citations in this area. Would you like me to suggest the doctrinal framework instead, so you can verify the authority yourself?" Ask ChatGPT the same question, and you are more likely to get, "Certainly. The leading authority on this question is Smith versus Western Mutual, 412 F. Tant 3D 1184, 9th Circuit, 2008, in which the court held, confident, fluent, often fabricated." This isn't a marketing claim. Claude isn't perfect. It also invents citations sometimes. The difference is in the calibration. Claude is trained with stronger uncertainty signals. It hedges, it asks back, it refuses to invent more often than ChatGPT does. For lawyers, that calibrated uncertainty profile maps better to professional standards than confident by default fluency. It's the difference between a tool that flags its limits and a tool that smiles through them. The duty to verify is not new. It is just newly tested. In the United States, Federal Rules of Civil Procedure, Rule 11, makes attorneys personally responsible for the contents of every signed pleading. ABA Model Rules 1.1, 3.3, and 5.1 cover competence, candor to the tribunal, and supervisory responsibility. ABA Formal Opinion 512, issued in 2024, addresses generative AI specifically. In Australia, the Australian Solicitors' Conduct Rules 4.1.1 and 19.1 carry the same weight. The state law societies in New South Wales, Victoria, and Western Australia have all issued AI guidance with verification at the center. In the United Kingdom, British High Court Justice Sharp's June 2025 warning was the loudest yet. Submitting AI fabricated material to a court could amount to contempt or, in the most egregious cases, perverting the course of justice. Maximum sentence, life. Whatever signs the brief owns the brief. 3 jurisdictions, 1 rule. This is the protocol the panel uses on every AI-assisted output that will be filed, sent to a client, or relied on in a matter. 5 steps. Run them before anything goes out. 1. Source check. Every authority gets verified against Austlii, Westlaw, LexisNexis, or the official court site before it leaves your laptop. Not the AI's confirmation, the actual database. 2. Quote check. Every quoted passage gets pulled up in the primary source and read in context. AI is not a citation tool, it is a drafting assistant. 3. Reasoning trace. If the AI made an argument for you, you reconstruct it from the underlying authorities. If you can't reconstruct it without the AI, the argument doesn't go in. You don't sign what you can't defend. 4. Disclosure check. More than 300 federal courts in the U.S. have AI disclosure requirements, and the list is growing. Australian state courts are issuing the same kind of guidance. Confirm the requirement for your specific court before you file. 5. Confidentiality check. No client confidential information into a public model, ever. ABA Opinion 512 is unambiguous. Australian state guidance is unambiguous. This is the rule that loses careers fastest because the breach is invisible until it isn't. Here is the take-home. AI is not optional anymore. Pretending it is just means your colleagues, your juniors, and your opposing counsel will use it without the verification habit you should be teaching. The choice isn't AI or no AI. The choice is supervised AI or unsupervised AI. The lawyers in Matta, in Whiting, in Johnson, in Dayal, in Nathwani, they all chose unsupervised AI. They didn't mean to. They thought the tool was something it wasn't. That distinction will not save you in front of a regulator or a Sixth Circuit panel. This is episode 1 of an ongoing series. The Hallucination Files drops every quarter. Every 3 months, we run through the new cases, the new sanction patterns, the new court rules. If you want a working lawyer's running record of AI legal failures and the verification habits that prevent them, subscribe so you don't miss the next one. The verification workflow from this episode is pinned in the comments below. Save it. Share it inside your firm. The next time someone hands you an AI-drafted brief and asks if it can be filed, you'll know exactly which 5 steps stand between your name and a sanctions order. That's the episode. See you in the next one.